Good morning. Welcome. We are very sorry for the delay. We had a technical issue. Welcome to this fourth edition of the AI Pact webinars. The AI Pact webinars are part of the AI Pact initiative, which is an initiative launched by the Commission to directly engage with stakeholders. So we'll take questions from the audience using the Slido application. So feel free to connect and to participate and to ask a question to our guest. Let me first introduce our guest for today. To begin, Tatiana Evas, you're a legal and policy officer. Then Irina Osic, you're the head of sector for governance and regulatory policy. And to finish, Jordanka Ivanova, you're the head of sector for the legal oversight of the implementation of the AI Act. You all work at the AI Regulation and Compliance Unit, which is one of the 5 units of the AI Office. Today, we'll discuss two important major topics: the definition of an AI system and the prohibited practices that fall under the Article 5 of the AI Act. Two main reasons for that. The first reason is that the provision on artificial intelligence and the definition of AI system and on prohibited AI practices enter into application in last February 2025. And the second reason is that the Commission released two major sets of guidelines on definition and on prohibited AI practices. So to begin, I want to begin with the definition of an AI system. Tatiana, could you present us the scope of the AI Act with a focus on the definition of an AI system?
Good morning, and thank you for this question. Indeed, AI system definition is very critical for the whole AI regulation. So it's not just a technicality or legal peculiarity of AI Act. It's actually the something on which all AI Act regulation builds, and let me explain why. So AI Act is a risk-based regulation, and it regulates AI systems based on risk. But what is AI system? That's the first question to be answered. And exactly that's where definition comes into play. So how we define what AI system ultimately helps us to explain what is in the scope of regulation of AI Act. And actually it sounds easy just to define what artificial intelligence system is, but in practice it was a very difficult task. And we have worked very closely also with international partners, particularly with OECD, to try to find a sound definition of AI system. And what is the challenge? Why is it so difficult? There are many different definitions of AI system, and actually the AI Act is the first legal text which defines what AI system. So the legal definition must be clear and precise also for the legal text. And as I mentioned, we work with OECD, expert community and different member states to come up with this definition. And OECD provided a definition which is a policy definition, which then AI Act in Article 3 translated into legal text. And what is the scope of definition? There are two kind of balancing acts were necessary. First, AI system definition must be not too narrow, because if we set it too narrow, then certain systems which could be dangerous for public interest, to health and safety, could fall outside of this scope of definition, and then it could open up dangers and lack of accountability. So this is definitely what we didn't want to have. On the other hand, if we set the definition too widely, we could impose unnecessary burden for industry and public administration without actually adding much value to citizens' protection or interest or public interest protection. So to set this balance between being too narrow and too wide is actually not that easy, because on one hand you need to define what is AI system, but on the other hand you have to somewhere put the limits, what falls in and what falls out. And exactly to define this system, the AI Act, like I mentioned, based on the discussions and policy consensus which emerged through OECD definition, which took a few years to negotiate. And AI Act actually translates this policy understanding into the legal definition. And in one of the slides, which you will see, it's the definition is provided, which basically says that it's a machine-based system, which based on the inputs it's received using inference, infers how to deliver outputs such as predictions, recommendations, content, and that these outputs can influence the environments, both physical and virtual. So that's the elements which we believe sets the right balance between being too narrow and too wide. And for that reason, the definition is very critical for the whole regulation.
Okay. Could you shed light on 2 or 3 major points to remember or to know about the definition of an AI Act, and in order to understand what kind of system fall under or on the scope or outside the scope of the definition?
Okay, thank you. That's a very good question. So in guidelines, we explain, we decompass, let's say, this short definition, which is in Article 3, and as it's further explained in Recital 12, into 7 main elements. And all these 7 elements help to define what AI system is. But if I have to pick few which are really essential and which help us to distinguish what AI system is and what it is not, I would want to focus on the concept of inference. So ability to infer how to. This is very important for the definition of AI system, because if we just speak about simple software, or it can have input and output, so also the elements of the definition, but ability to infer how to reach outputs based on inputs using AI techniques is really essential. So the concept of inference as a process and as output is really essential. And Recital 12 further explains that this process of inference this inference should be based on one of AI techniques. So, for example, machine learning, knowledge and logic-based approaches. And here, coming back to your second element of the question, what is in and what is out. So what was, as I mentioned before, we didn't want to set the restriction too wide. So definitely what is out is very basic input-output systems which are manually programmed by individuals, so rule-based systems. So we didn't want to, and I want to really stress that AI Act does not regulate simple calculator, simple spreadsheet, simple thermostat, which is just based on fully pre-programmed if-then rules. And this is the misconception sometimes we hear, that AI Act covers all data processing and rule-based approaches. No, AI Act does not cover simple thermostat. At the same time, AI Act is not limited only to advanced machine learning techniques. So as I mentioned, Recital 12 clearly says that AI techniques include machine learning techniques, but also logic and knowledge-based approaches. This is also important to understand. So AI system definition, on one hand, is not as broad as to cover every data processing system, but at the same time is also not limited to only advanced machine learning systems, which, for example, continue to adapt and after deployment. For that reason, all the same elements which are listed there is important, but again, to stress, really key to understanding and distinguishing AI system from other type of software systems is ability to infer how to reach outputs using AI techniques, which are not limited to machine learning.
Okay, thank you. It was really important to precise. Before we move to the prohibited AI practices, just a few words regarding the risk-based approach. We've already presented the risk pyramid, but maybe it's important to say a few words about this pyramid. Could you, Tatiana, present us the pyramid just in few words, please?
Yes, this is a mark sign of AI regulation. I think anybody who heard about AI Act definitely familiar with this pyramid, but I'm happy to present it. So actually the logic of the risk-based approach, which is really foundation of AI Act, which is pro-innovation regulation, which wants to set public guardrails in the right way. So risk-based approach is based on very simple logic. The higher the risks related to AI systems, the higher burden of regulation, let's say, or higher regulatory requirements apply. And if the AI system doesn't have high risks, then the regulation is minimal or no regulation. So if we look at this pyramid, at the top of pyramid in the red zone, which is very top of the iceberg, if I can say so, is unacceptable risk or prohibited practices, on which my colleagues will explain in more detail. So this is something which will be prohibited from the use on EU market for the reasons which we will discuss before. But this is really a top of the pyramid, which is very thin layer. When the second layer is high risk. So here again to say that for high risk use cases, and here again we don't speak about specific technologies, but about use cases, which systems are allowed. So we are encouraging the use of these systems in the EU market. We encourage innovation in these systems. We encourage uptake of these systems because they can bring a lot of societal benefits, among other things. So we want this system on the EU market, but we don't want these systems without public check before they are on the market. So here again, the logic is very simple, and I think now it's very familiar for many that we don't want to fly in airplane or in a car which has not have been checked for safety. So the logic is the same. We don't want AI systems used in medical devices, in recruitment, in law enforcement without being checked for its safety. So the high risk cluster is basically saying, yes, let's use these systems, but let's check that they are safe. Then next layer is so-called systems with transparency risk. So the layer of requirements or applicable or obligation applicable to these systems is very thin. Basically, it's about transparency and disclosure obligations. So for example, chatbots. And finally, which is actually the biggest layer of the pyramid, is minimal or no risk, to which there are no additional regulations applicable from AI Act.
Okay, and just before we move to the top of the pyramid, we have a first question on Slido about an AI system for cars. Does it fall on the AI Act or no? Could you elaborate about cars?
Okay, yeah, I like cars, so it's a good question. So indeed, so type approval legislation is listed in Annex 1, Part B of AI Act. Therefore, the AI systems integrated in cars, so in vehicles, are covered under high-risk AI systems provisions. So if the software systems falls into the definition of AI system, and it's subject to type approval legislation, so in Annex 1, then yes, the vehicle will fall into the high-risk category of AI Act.
Okay. Thank you. Let's move to the top of the pyramid and with unacceptable risk AI system. Irina Yondenka, could you sum up the Article 5 of the AI Act and present the guidelines, the context of the guidelines and the background? Who want to start? Yondenka?
Yes, thank you very much. I'll start and say that indeed these are very important guidelines that we produced that aim to further provide clarifications, practical examples for the prohibited AI practices that are on the top of the risk pyramid and that have been really considered by the co-legislators as incompatible with our values and fundamental rights, so inherently harmful that they should not be allowed in Europe. And we have 8 prohibitions, starting here with the first slide. You see the first one really focuses on AI systems deploying subliminal, manipulative or deceptive techniques that are capable or used with the objective to materially distort people's behavior and in this way causing them significant harm or likely to cause such harm. So here this really aims to address very harmful practices that are really harmful in the sense that the threshold is not just minor possible inconveniences or potential harms, but really unacceptable harms that are for people or groups of people and that undermine through these subliminal, manipulative or deceptive techniques the individual autonomy and free choices of people. And there are various examples. We've been really grateful from all the stakeholder contributions we've received with practical cases where we've tried to distinguish what could be these harmful practices, like, for example, chatbots promoting self-harm or other very addiction-like behaviors, or incentivizing people to commit other harmful acts compared to other practices that are not actually undermining individual autonomy or that are not causing such harms. And the next prohibition is phrased very similarly, because it also aims to protect the free choices and autonomy and safety and rights of people, but it focuses on a very particular groups. And these are mainly to avoid AI-enabled exploitation of vulnerabilities of three groups of vulnerable people due to age, mainly children or older persons, disability, or persons in a very specific socioeconomic situation, for example, unemployed people or people in extreme poverty. Because of the potential of these AI systems being targeting specifically these vulnerabilities, and in this case causing them also such significant harms, these practices are also prohibited. And there are various examples for these groups, in particular, for example, for children. We would not like to have AI applications in Europe or toys that are really incentivizing children to commit harmful acts and that could be very dangerous for them. The next prohibited practices concerns AI used for the evaluation of or classification of people in public or private context. So that's very important, because it has a broad aspects in place when AI based on the social behavior of people or on data also for their personal characteristics, like, for example, where they live, what kind of family composition they have, nationality, and others, are used for the scoring of these people with the AI-enabled social score leading to detrimental or unfavorable treatment. Either because of the data that has been used for this massive collection and evaluation comes from unrelated context for the purpose of evaluation, so there is very clear discrepancy and no apparent connection, or there is also a second example, if the disproportionate or detrimental treatment is not proportionate to the severity of the social behavior. And here there are different examples also in the guidelines. For example, AI being used by public authorities, for example, to profile citizens for whether they are likely to commit fraud based on very broad, unrelated data for social connections that are and other hobbies and other data that is really not relevant for the purpose. Then we move to the fourth prohibition, which is when AI is used to predict or assess the risk of the likelihood of individual persons being likely to commit criminal offenses. And this should be solely based on the profiling of the persons or on the assessment of their personal characteristics. So here we have, it's important to say that there are quite beneficial in certain cases predictive systems that could be used in context for law enforcement purposes, but at the same time there could be, this is what this prohibition really targets, are these unacceptable practices when the predictions for people whether they are committing crimes are solely based just on the profiling of the people as the main factor, or on the assessment of their personal characteristics, for example, how they look, or what is their nationality, where they live, which without any objective and verifiable facts should not be used in Europe as a basis to consider these people as potential suspects. And there are also very clear exceptions exactly to draw the line between what could be lawful and acceptable, and for example, AI being used to support human assessment based on such kind of objective verifiable facts, as opposed to really unacceptable and prohibited. Like a sort of Minority Report, if you have looked at film, and some other cases we have also put as examples. And
Okay, great.
Irina?
Okay, then I will guide you through the next 4 prohibitions. So the first one is the untargeted scraping of images from the internet or from CCTV material to create or expand facial recognition databases. What is important here is the untargeted scraping. It is like using a tool to go through social media to build up a database of all the images there, and possibly also to add metadata like where these pictures were taken. So this would be prohibited. What would not be prohibited is the targeted search for one individual, like I'm searching for one person and I use a tool to scrape the internet. And what also is not prohibited are other than facial recognition databases. So for example, training databases to create synthetic pictures or something. Here it is important to note that data protection rules also play a very important role. Then the next prohibition is about emotion recognition at the workplace and in educational institutions, with the exceptions when there are specific medical or safety reasons. So emotion recognition is prohibited in these 2 places against the background that here we are having very hierarchical relationships. And emotion recognition systems do not work very well. Probably they will not work very well whenever, because just there is such a cultural difference also in emotions, and what is one movement for one person from a certain place can be very different for somebody coming from another place. And in these relationships at the workplace and in education institutions, indeed the use of such systems can have a massive impact on your future life. So for example, being used in call centers to check whether people working there always use this very nice tone of their voice and seem to be happy, appear to be happy. And if not, it goes into like your personal file. This might impact your job. The observation of employees at the workplace, again, to see how happy they are, can have an impact. The same to see whether pupils or students seem to be bored. So against this background, we have here in these 2 fields the prohibitions. There might indeed be medical reasons to use such systems, but that would not include reasons of well-being at the workplace, but hardcore medical reasons. And there might indeed be also safety reasons if, for example, people are working with dangerous machines. It is important to see whether they are concentrated, awake, and everything. Now, the third prohibition refers to biometric categorization systems, assigning individuals to certain sensitive, protected categories. And here we have, for example, the political opinions, we do have the sexual orientation, we do have the race, we're having philosophical beliefs. So what is important, and that it was also for the emotion recognition, is that it is based on biometric data. So a categorization according to the fact whether somebody is wearing a red scarf would not fall under the prohibition. But for example, tattoos, color of skin to then infer on the race of the person, or from a picture to see what could be the sexual orientation or political orientation of a person, that would be prohibited based on the biometric data. And these systems exist. Then we have the last prohibition, which is the real-time remote biometric identification for law enforcement purposes in publicly accessible spaces. So again, we're having the biometric data, we have it in real time, we have it for law enforcement, for nothing else, and we have it in spaces that are accessible to people. But we also have 3 exceptions, because we know that there are situations where law enforcement authorities need to use these systems. So we do have the exceptions when looking for missing persons, when there is a serious threat of danger to life or of a terror attack, and to look for people who are suspected or also who have committed a serious crime. In that case, an authorization is needed before using the system. It needs to be proportionate, so it's clear that the system can only be used for a given time at a clearly defined place on the necessary number of people and nobody else. There is a fundamental right impact assessment and a couple of other requirements, and also member states who want to make use of these exceptions need to transpose them into national law. So as long as there is no national law, the real-time remote biometric identification for law enforcement purposes and publicly accessible spaces remains completely prohibited. Thank you.
Okay, thank you. We'll have time to talk about certain prohibited practices, but first, could you explain the background of the guidelines? I'm sure a lot of persons in the audience have seen the guidelines on prohibited practices. Could you present the background, the drafting context of these guidelines, please?
I will do that. So the context is that Article 96, I think B, of the AI Act says that the Commission is going to adopt such guidelines. So it is a Commission document with the consequence that it is, or as a communication, it is not binding, but it gives some indications. At the end, it's always the court to decide, but we have also internally discussed with many lawyers to make sure that we come to conclusions which most likely would be upheld by the court. We do not have only discussed internally with lawyers, and we are all lawyers ourselves, you see us sitting here, but we also had broad consultations with the member states, we talked to the European Parliament, but in particular we also put a stakeholder consultation online for, let's say, the whole world. And what we were in particular asking for are use cases. So what kind of case do people know where they wonder whether this case would fall under the guidelines or not, and whether just from the wording of Article 5, further clarifications were needed in terms of definitions. And we had many comments, many submissions, and we, as far as possible, we were incorporating them into the guidelines. Now, these guidelines are a living document, and we all know that the technology is extremely dynamic, which means that we are happy if you have more use cases, if you have still unclarities, if new tools come up, to send them to us. So we will also publish a certain moment questions and answers in the internet when we have important new use cases and important requests where we find that this has not sufficiently been addressed in the guidelines. We can indeed revise them, but we can also already publish in particular questions and answers with regard to the guidelines. Also from summer onwards, from August onwards, we are planning to establish a service desk that will help everybody with questions and answers, not only on the prohibitions, but in general on the AI Act, but also when there are questions on prohibitions, the service desk will be able to help.
Thank you. We have a question from the audience. What if an AI system has multiple use cases? What are the provisions to apply if it is both prohibited and high risk? We'll talk later about the interplays, but if there is multiple use cases, want to answer to this question? Maybe Tatiana?
Maybe I can start and my colleagues can complement.
Mm-hmm.
So indeed, one of the key characteristics, or let's say that helps to classify systems, is intended purpose. So we look at the intended purpose of AI systems. So we don't regulate specific technology, we regulate specific use. Therefore, it's important to look at the intended purpose. And of course, if intended purpose of the system is prohibited, the system is prohibited. But one and the same type of technology or system could be used in different contexts. So if specific use case is prohibited, it clearly cannot be used. But if other context or use case which falls into high risk category, then of course this intended purpose and this system which is intended to be used in the high risk area then need to go through the rules and requirements applicable to high risk.
Okay. Do you want to add something, or?
I think yes, maybe I could complement that there could be certain cases indeed because the systems could have multiple purposes and because, for example, the prohibitions also cover the placement on the market of these systems. As Tatiana explained, it has to be carefully assessed within the responsibility of providers, for example, whether they have, and the system, for example, some of the prohibitions, in particular those with general purpose that we could think like chatbots, for example, could display some of the prohibited practices like manipulative and very deceptive techniques, then they could potentially be considered under the prohibition if all the conditions there are fulfilled. So that's very important. At the same time, just a chatbot, when it's not a high risk, when it's not a prohibited and very harmful system deploying these harmful techniques, then it would be just subject to, for example, the transparency requirements, because people have to be notified when they are interacting with an AI system. There could be potentially cases where, for example, a chatbot will also be used for high-risk intended purpose, as we have for the categorization when all the requirements have to be fulfilled, also in some critical context. For example, if the chatbot itself, let's take one example from Annex 3, is for really interacting with individuals, making concrete assessment of their individuals, and then making concrete recommendations afterwards to public authorities, for example, whether to give that person a specific public benefit. So in that case, you could have a high-risk system. So that's why it's very important for indeed every provider to assess and be familiarized with the different categories, and we are also helping in the future with our guidelines now, but also planning in the future to provide even more for high risk and for the self-categorization of the different layers.
A very good question. I would like to add as well. No, I just would like to give you some practical examples from the prohibitions we had just discussed. So, for example, you have systems that are used frequently by police that look at suspected, like things where you suspect, they could imply a crime, like a suitcase that has been lost somewhere, or bags that look dangerous or whatever. So this would not be subject to anything. But then they will look at the people around the systems and, for example, check their emotions. So if it is not workplace, indeed, it is not prohibited. And as a next step, these systems might also then try to identify the people. And here we might very well be in the field of the prohibition. And so we have quite some examples of systems that are very complex, that are prohibited, high risk, subject to transparency and nothing. And indeed, as it was said before, it always depends on the concrete use of it, which of the rule would apply and what use would apply. Like you have a prohibition of biometrics for certain cases in the field of law enforcement, under the AI Act, but for other reasons it would not be covered by the AI Act. It could be still one and the same system.
Thank you. Now let's turn to the topic of the exclusion. In the AI Act there are several exclusions, particularly for research and development or for personal use. Jordanka, can you explain to us what are these exclusions? How does it work? I'm sure it's a question I see in the audience.
Yes, indeed, that's a very important question, because in addition to the AI Act, AI system definition, we in the scope article have also specific provisions that further clarify in certain cases whether certain systems could be excluded in general from the scope of the Act. And although the guidelines become a bit longer, we felt that there is a need of clarifications also in those aspects. So one of these exclusions is indeed in relation to research and development, and there are two relevant provisions. First, it's very much linked to the market-based logic of the AI Act, which kicks in only after a product is placed on the market or put into service. So in general, research, development activities that are already done before that stage are not affected and excluded. Of course, once the product or the system is based on the European market, it has to be fully compliant. So in certain cases, to achieve that could also require further actions before that. For example, how you design the system, how you do conformity assessment if it's high risk. But it is only in case this system is intended to be and ultimately placed on the market that this would apply, while the previous phases are in general out of the scope, and that allows also innovation and research. There is also a specific exclusion for AI systems being specifically developed or put into service for the sole purpose of scientific research, and this is in addition. So in that case, we think, and this is aligned with the freedom of science and also innovation, because sometimes actually these AI systems also could benefit to improve safety or to identify risks, but it's very important that this should be for the sole purpose of scientific research, and that of course still the existing EU legislation and also even compliance with ethical research standards remains valid. So one example is, for example, we have the prohibition for subliminal manipulation in this very harmful context, but if we just do research for the sole purpose of scientifically examining these things without actual impacts and real world testing, that's also very important on people without causing or having direct interactions. This would be fully possible and excluded. At the same time, if we have AI practices that are really employed in actual real-world testing and with actual people, that would be covered, and there is a special regime under the AI Act for real-world testing, and also regulatory sandboxes where there are still possibilities to have, not for prohibited practices in terms of really doing harmful things, but in collaborating with authorities to still innovate and do real-world testing in a more specific regime than the full application of the AI Act.
Does it mean that prohibited practices could be tested in real world but not in sandboxes? Am I right?
I think it's not to test prohibited practices, because as such, when I said if it's real world testing, when they have these harmful impacts, they should be prohibited in general. But sometimes there could be unclarities, or for example, specific legal aspects that need clarification, where also further engagement with supervisory authorities could bring and help providers to actually understand, mitigate risks, avoid the prohibited practices. So in this case, that collaboration is very important, and that's one of the main purpose actually of the sandboxes. It has to be, clear that it's not that they can be started to be tested and achieving these harmful effects, but rather mitigating and identifying more the harmful impacts, so they are avoided beforehand in dialogues with regulators.
Okay, thank you. And what is the difference between exclusion for research and development and personal use? It is the same or not?
Yes, no, it's not the same. So that's indeed very important. The exclusion for personal use, we have to clarify that this applies only for the obligations of deployers. And we have to draw the distinction that also the prohibited practices, most of them, with the exception of the use of real-time remote biometric identification in publicly accessible spaces, they cover both the placement on the market and the use. And also most of the provisions of the AI Act as well provide to both categories. The deployers are a very specific category, and these are only the users under whose authority the system is used. And what the AI Act excludes is only in relation to their obligations when these deployers are using the AI systems in the course of personal, non-professional activities. So these are really like, for example, students or normal persons who just use AI for summarizing, making their own work. And this should be distinguished, for example, for the obligations from for deployers for professional purposes, for example, like journalists or employees in companies or doctors. So all these obligations still apply, also even for high risk. So it's very limited only for the deployers' obligations for these non-personal and non-professional use context and activities.
Okay, great, thank you. Let's move to the interplay between prohibited practices and high-risk system. As you mentioned it before, sometimes prohibited practices are allowed when there is some exception. For instance, regarding emotion recognition, it is sometimes prohibited and sometimes not. And what it is when it is allowed to deploy an emotion recognition system, does it fall under the category of high-risk system, or is it the no-risk category? How does it work?
No, yes, absolutely. Emotion recognition systems would fall under the high-risk categories and would need to comply with all the requirements. This is for most of the prohibited practices the case, like where it's not prohibited, it would be high risk. So for example, we have the prohibition of social scoring, but we also have a profiling risk, high risk use case. So yes, and then the requirements need to be complied with, and perhaps just since the rules on high risk now for these cases, Annex 3, enter into application only in August next year. On the Annex 1 cases, so the ones who are safety component of an already regulated product, it will be even 1 year later. There will also be guidance in due time. So what you saw here for the prohibitions, you will then also see for high risk, and you will also see standards and everything. And perhaps just a last word, that it's not only high risk, but for example, for emotion recognition, but also for biometric categorization, it would also fall under transparency requirements. So if such a system is being applied on a person, independent from the context, so for example, for advertising purposes also, the person needs to be informed about it on top of the high risk.
Okay, thank you. And the AI Act is not the sole text applicable to AI. There are a lot of regulation in Europe that is applied to AI system. I think about the GDPR, for instance. Could you explain to us how does it work? Can we imagine some prohibited practices outside the Article 5 of the AI Act based on other regulation?
Plenty.
Plenty, yes. I'm sure plenty, but
no,
could
indeed.
you elaborate?
No, indeed. There are prohibited practices, and if we look, for example, at the remote biometric identification, we said it's for law enforcement purposes, which means that for any other purpose, it would not be prohibited. So there might be a system used, let's say, in a shopping mall. If this system is being used by the police for law enforcement purposes and all the rest of it, it falls under Article 5 of the AI Act. If the same system is being used by the owner of the shopping mall or by a certain shop or something, it falls under GDPR. And most likely it would be prohibited as well. It always depends indeed on the concrete circumstances.
Okay, thank you. And before we move on to the analysis of certain prohibited practices, a last question on definition for you, Tatiana, regarding there are a lot of questions on the difference between AI system and models. So could you give us just a general overview of this point, please?
Okay. Yeah, so maybe I'll start with the scope of AI Act. We have two big parts, let's say. One is related to AI system, which the guidelines we published in February and which I tried to explain shortly today. Another big part of the AI Act concerns general purpose AI models. And of course, we have both definition of AI system in AI Act in Article 3, but we also have a definition of a general purpose AI model. And the regulation or provisions applicable to general purpose AI models are different. And we have two categories related to general purpose AI models. One's related to, let's say, general purpose AI models as a lower risk category, and another one is general purpose AI models with systemic risks. So it comes at a different stage of life cycle of the product. So, and as I said, there is specific definition of general purpose AI model included in AI Act, which should be not confused with AI system definition.
Thank you. Anything to add on that or no? I suspect we had a focus on first prohibited practices, harmful manipulation or exploitation of vulnerability. There are a lot of questions on Slido regarding this use cases. So what is an harmful manipulation? and what the exploitation of vulnerability mean. Could you elaborate on these first prohibited practices from A and B of Article 5.1?
Yes, indeed. There are specific techniques that are deployed by these systems, in particular in the first prohibition. These are subliminal, manipulative, or deceptive techniques that the AI systems must deploy themselves. And these techniques could be applied in combination, or each of them could be deployed depending on the different context. Here, subliminal should be understood as techniques that affect peoples beyond their conscious awareness. So this is really that we are exposed to stimuli that are deployed by these systems that are not perceptible to our normal senses. For example, what we hear or what we see. But these techniques are still capable of subconsciously influencing our predisposition, our behavior, and in this way nudging and substantially influencing, so that's also an important element of the definition, how we react and how we behave. And when, of course, this is significantly harmful, because then the prohibition applies, this would be prohibited. Another example are for the purposefully manipulative techniques that could be also acting below our conscious awareness, but even in some cases we could be consciously aware, but these techniques could still exploit our psychological vulnerabilities, for example, or cognitive biases or predispositions, and in this way we could still be materially influenced to take decisions against our free autonomy and will and our free choices. So, for example, there could be cases where a lot of personal information, a lot of information about these vulnerabilities, specificities, or even systems in certain cases that really predict our emotions in very concrete cases, or based on multiple interactions, really reinforce us into behaving into a certain way and acting in a specific direction that we wouldn't have done if we were not exposed to this. That is also another example for purposefully manipulative. Then deceptive should be understood as techniques that are or AI systems actually that are deploying false or deceptive, misleading information, and in this way they are deceiving us. So there are a lot of examples, as we know, for example, in deepfakes, or like recent cases where people could be impersonated, and in this case, when it really leads to significant harms, like, for example, there was a recent case where like a CEO person was presenting themselves for CEO managers, or even we have had cases before with president candidates trying to manipulate people that they are actually the ones, while they are, in this case, obviously being so realistic that people are just deceived and follow that. So in that case, when they actually act against their free choices or will and are clearly subject to these scams, then when this causes them significant harm, this could also be covered. In relation to the exploitation of vulnerabilities, I want to repeat again that this is for very specific groups of vulnerable people, because while the first prohibition targets all of us as natural persons, this one recognizes with the second one that certain groups like children or these disabled people, they already have these vulnerabilities that really make them more vulnerable to even beyond the rational barrier of all of us as persons. They are more vulnerable, and they can be also subject to specific exploitation that really targets their vulnerabilities, like, for example, systems that are interacting with children and really trying to exploit their naivety, their predisposition to become more addicted to certain services, to be more easily misled because they are very credular, and in this way start to either behave in a harmful way for themselves, or for example spend a lot of money, and when the systems are exploiting very in a targeted way these kind of vulnerabilities, that could be an example for one of the cases, but there are many we've tried to put, and indeed these prohibitions, we see there are a lot of interesting examples. So what Irina also mentioned, that technology is evolving, we have also a lot of cases, and with the application we really want to gather more evidence also for consistent understanding and also interpretation, and support everyone also in the application in an effective and consistent manner.
Thank you. And on the vulnerability, is there a definition of vulnerability? Does it include economic vulnerability?
The AI Act as such, when we have these groups that are defined by age or disabled people or persons in this specific socioeconomic situation, says that any vulnerability of these persons could be covered. So that's why these are like weaknesses that really are characteristics for this category of persons that could be covered, and they could be a wide variety. I mentioned just for kids, like some of them, we've seen, but they are broader, and there are some examples in our guidelines, but as said, these are also concepts we've tried to just propose first guiding principles of understanding, interpretation, and then it will be very importantly a lot case-by-case assessment in specific cases to assess and also identify whether all these conditions are fulfilled.
Okay, thank you. We have a lot of questions about social media. Social media algorithm could fall under the manipulative technique or subliminal technique. I guess the answer will not be yes or no, it depends, but what can we say about this topic of social media algorithm?
Yes, the AI Act is a horizontal legislation, so it applies to all sectors. That's very important. So any AI system as such that could be used in different contexts, be it social media, be it financial services, be it public authorities or cars, as mentioned before, like Tatiana, could potentially be covered because of the broad scope, with the exception of the exclusions we discussed before. So if all conditions that are very specific here in each prohibition are fulfilled and it's demonstrated, it is possible that there could be systems in those contexts that could fulfill the prohibitions. At the same time, as you rightly mentioned, there is also a lot of other legislation that applies in addition to the AI Act. So it also plays an important role, this other legislation, to often avoid the harmful effects with certain mitigating measures or transparency or other measures, if they are envisaged, or even risk assessment and mitigating measures to avoid that we would have situation that you would be prohibited. So that's an important element also, and that's why in the explanations for each prohibition we have this specific section also for interplay with other existing legislation, and also how compliance also of certain, specifically in this case when personal autonomy is respected, when the techniques are also transparent, they are not deceptive, and there are safeguards to avoid these significantly harmful effects. These systems will not be prohibited, and yes, there is this strong reliance and building on other legislation that can also help to achieve that.
Okay, thank you. Let's turn to another prohibited practices, social scoring. With you again, Jardenka. Could you could you explain to us what is this prohibited practice on social scoring? I'm sure it maybe include the Shufa case, but maybe other things. Can you present this important point, please?
Yes, thank you very much. That's indeed also an important broad prohibition because, as we said, it could apply both to public sector but also the private context. And as you said, it really targets this kind of cases where people are evaluated, classified based on a lot of their personal data. Often it could be clear data that we know, but very often it could be just predictions, assumptions for those people, and often, as said, also based on multiple information about their behavior in very, very different contexts. And for people familiar with big data profiling, or now we've seen with technology where these mass collections of data could be compiled from different data sources, really to create these complex evaluations for the people, and with using the social score for very practical cases, like, for example, we've seen even, yes, we all know some countries that are really broadly doing mass surveillance and profiling of people, like in other third countries, for example, prohibiting them from traveling or using public services. But there could be even more specific cases, like, for example, employment agencies profiling applicants for employment benefits based on very broad information, their social behavior that in certain cases could be very relevant, like their past jobs, for example, specific skills, but often it could well go beyond and involve unrelated information, like, for example, what are the health conditions, or for example, hobbies, or also very personal, unrelated information for this kind of assessment. And these are cases where really this prohibition wants to prohibit this generalized information of data from many unrelated contexts, or when people are disproportionately harmed and prevented from access to certain benefits, for example, or when they are profiled as being committing fraud for obtaining household allowances, for example, just on very minor and irrelevant information to make that assessment. But it is very important also here to stress for that prohibition that we really, what it actually aims is precisely this unrelated, disproportionate scoring of people, and not all these existing very lawful and legitimate practices for evaluating people for specific purposes, when we often have a very clear even specifications and specific laws what data should be used for that assessment, how this assessment should be done. All this is perfectly lawful organizations, and we've also tried to give a lot of examples what are these kind of all lawful practices, because it's very important also to interpret this prohibition in a restrictive, targeted manner, what is actually unacceptable, harmful, from what all these good practices also that AI can actually help and support to improve efficiency, accuracy in specific decision makings when the data is very relevant, concrete, and that we have tried also to clarify it in the guidelines.
Okay. We have a question from the audience at the interplays of harmful manipulation and social scoring about marketing and advertising algorithm. Can you say a word, you or Irina, about this point?
I think there could be cases where a practice could potentially capture different things. For example, in advertising, I think this should be really exceptional case, as we hope that these practices, these advertising techniques, normally they are transparent, they are not profiling people on broad kinds of personal information, and then really exploiting very specifically their predisposition, for example, in very specific cases in ways that they should really influence them and have an actual impact to make the person buy in a very specific context, very specific product because they urgently need it, and this product, for example, is presented at a very, very high price. So we still have to keep in mind we have to have the threshold of significant harm. So in such kind of exceptional circumstances, which we really hope that's not what is happening on the advertising market, but there could be kind of purposefully manipulative practices with such kind of harmful effects. If all these elements are cumulatively in place, that could be prohibited under the first point. At the same time, for the social scoring, there could be, if in the end there is a case where all this social scoring evaluation is done on very broad personal data, completely unrelated for the purpose, and then if this leads to a very significant, also detrimental, unfavorable treatment based on also on this unrelated context, and obviously this is done also, I think it will be likely done also in violation in a number of other legislations, there could be also cases for the social scoring. But they contain different elements, and they aim aim to protect different fundamental rights, right? In a way, one is really people not to be manipulated, while the other one is more related that they should not be subject to all these generalized surveillance and social scoring to really for the social scoring prohibition.
Okay. A question on social scoring about consumers. Consumers used to have a score from platform or different services. Is it a social score or it is an economic score? Is there a difference between social score for consumer and other, or it is all the same? We don't distinguish the 2 points. It's a question from the audience.
That's a very good point for the evaluation, concrete rating of whether it's consumers or just drivers in social in platforms and others. So important point for the prohibition on the social scoring is that the evaluation should also evolve over a certain period of time. So it's not just one-time evaluation, and it always has to be done based on this broad information for the social behavior or personal characteristics, in a way more comprehensive evaluation. So we have to distinguish it, for example, where someone is just using like a taxi and they are just rating afterwards the performance of the customer, or when you go to R&B accommodation and afterwards you rate how you felt the experience. So this is really one-time assessment. This has nothing to do with AI. Really, as we said before, the involvement of the AI system is really important for making these evaluations and classifications based on this broad personal data for some of the practices, and especially including the social scoring, to apply.
Okay, and how this provision relates with other EU regulation on non-discrimination? Can you explain the interplay between these two kind of regulation?
Yes, that's an important point indeed. There could be cases where this detrimental and unfavorable treatment could lead to non-discrimination to discrimination as well. But the discrimination as such is a very specific legislation that applies only to certain protected groups, like, for example, based on race, gender, age, and there are specific circumstances when this unfavorable treatment, you have to prove that it would be disproportionately affecting only these specifically protected groups. While the social scoring prohibition could apply also, for example, in other cases where you do not necessarily only protect these groups of gender or age, race, but it could apply just to also normal citizens. So in a way, discriminatory cases could be covered, and that could be a harmful result of the social scoring, but there could be other instances when the social scoring prohibition could apply, so they are also complementary.
Okay, thank you. Now let's turn to real-time remote biometric identification system. We talked about it before, but Irina, can you explain it in more detail? What is it? What is its use case? And explain to us with some example. And for instance, what concretely means confirming the identity? It is a question we have on Slido. Irina.
Thank you. So real-time remote biometric identification means, first of all, real-time is live. So it is like somebody is checking in that very instance a person. And now indeed this invites a bit to circumvention. So you have like, you have a system that is running somewhere, and then you say, fine, I will send the biometric data only 2 minutes later or 3 minutes later for identification. That indeed we would like to see included in real time. And what we said internally is, if you have now a Saturday morning shopping street and you send the data like a few minutes later, you cannot expect that the person is still there. So that would not be real time. But if, for example, you have a concert or a football match and you screen the people who go in and send the data a couple of minutes later, you can expect them to still be there. So there one would need to check whether that would be a circumvention. So this is the real time. Then we have the remote biometric identification. And with remote, we mean that it is at a distance, but in particular without the active participation of the person in question. So for example, there are many tools where I do actively participate. There are countries where banks use systems, if you go to a cash point, to identify people via their iris. There are systems that give access to buildings based on biometric data. So all this, you go there, you consciously do it, you want it. So this is not covered by the prohibition. What is covered is again like the gathering of data somewhere in a shopping street, somewhere at a place where even one might see that there is a camera, but these days there are anyway many cameras, but it's not that I'm getting there smiling saying, please identify me now, but it's rather, it happens, so no active participation. I think that's the essence. We also have the law enforcement purposes, but I think that is rather clear. That excludes indeed administrative fines. So it's really law enforcement, like police, criminal offenses, and biometric data. We had this before.
And we have a question on crime prediction. Could you explain us what is crime prediction? What does it mean as a use case?
Actually, the crime prediction goes more to your Danka.
Okay.
Let me just, before that,
sure.
go back to your one question you had
Okay.
about confirmation of a person. Because indeed we have the identification in remote biometric identification, and that means that I put a name on somebody. So somebody screens me and says, this is person X. But we also have situations where you cannot immediately confirm the identity because you don't find it or you don't know it or for whatever reason, but you want to follow a person. You want, for example, you have somebody who committed a serious crime, you have the material, you want to follow to see where that person is going. Possibly for later identification indeed. And that would also be the situation you were talking about, that would be covered as well.
Okay, thanks. Janaka, you take it on crime prediction?
Yes, so indeed that's the fourth prohibition we were capturing. And crime prediction, here crime is again criminal offense. That's very important because this prohibition also doesn't apply to any administrative offenses. But there are multiple systems now that could be used in different contexts where AI can be actually quite helpful based on different data to predict the likelihood of people to commit criminal offenses. So it's very important to distinguish this case when people are actually being profiled and assessed for these predictions that are for the future. That's also very important. It's not for the past, this is for the future because it's about risks in the future and predicting of someone doing something in the future or in the course of taking actions to commit a crime. From other crime predictions that are primarily based on for the police work to determine where a crime could occur in a specific area or place, like in neighborhoods, that the police could think that because of the crime rates there or specific places, they want to dispatch their police officers. And what's really important for the prohibition here is that it targets the individual crime risk assessment where people are profiled, not just when this is our crime prediction based on places or locations that are outside the scope of this prohibition. And also very important to say, to remind everyone that the prohibition applies only if it is based solely on the profiling of the people and the assessment of the characteristic. And as we discussed before, the pyramid, in other cases, when this is not solely based on these characteristics, the system, when used by law enforcement authorities, would be still high risk and would be still subject to safeguards to make sure really that these are transparent, subject to human oversight, that are non-discriminatory, and with all the safeguards, protections that the AI Act envisaged for their use. So even in those cases, because indeed in certain contexts, even if it's not solely based on this profiling, there could be these risks, and with the safeguards and the requirements, the objective with the AI Act is to mitigate, to make these systems compliant, and to allow also their use to support the work and to bring the benefits that they could help.
Thank you. We have a last question from the audience. This question is not on the scope of this webinar, but it is important about the governance. Which authorities will oversee, enforce the AI Act? Who want to answer this basic but important question? Tiana?
Yeah, I'm happy to info. Like we started our webinar with explaining that it's a risk-based approach, and it's based on a lot of inspiration of AI Act comes from product safety legislation, which EU is very well established. And this product safety legislation logic, which we enhanced through AI Act, but the general logic is this, is based on the governance system, which is on one hand it includes bodies which are responsible for the pre-market evaluation, so like conformity assessment bodies, but also after the product is on the market surveillance authorities will oversee the correct implementation of AI Act. So it's very important that we have AI office which will coordinate, but also the correct and effective application and enforcement of AI Act will depend very much on national competent authorities, so market surveillance authorities, be it for prohibited practices or high risk or transparency obligations. That's the market surveillance authorities, the main responsibility, of course, in close coordination with AI office. And maybe also important element of this governance system, so national competent authorities, we also have last year established AI board, which is the main interface between AI office and member states authorities. So member states have nominated representatives to AI board. So AI board is a forum where AI office directly interacts with member states to get also information on how this governance system will work in practice.
Okay. Thank you. So we are reaching the end of our webinar. Two more things before we end. First, your feedback is invaluable. There is a survey in the link on the video description, so please take a moment to share your thought and to participate. It's important for us. And the second point, we're launching an interactive online community space soon in order for AI Pact members, in order to directly exchange and discuss between AI Pact members and with the AI office. Finally, a big thanks to the whole team behind the scene that make it possible. And our next webinar is on May 27, and we'll talk about the AI continent action plan and apply AI strategy. Thanks a lot. Merci beaucoup. À bientôt.